like to thank Brenda and the board for asking us to participate in this today. Before I ask Jason to come up and do the meaty part of our participation in this today, I'm just going to comment on one or two points on the agenda item. Jason is going to go through. What we've done is we have a draft agreement that we've actually done up at the request of the board and the association, because as many of you may know, as part of our role as counsel to the MTA, we field a lot of questions from some from clinic owners, but the majority of them from actual individual RMTs about questions, and mostly relating obviously to the business side of the professional practice. And as we've been doing that now for a number of years, and it's pretty safe to say that the majority of those questions that we get are all questions that should have been, and in some cases were, canvassed in the agreement that they have with their clinic. And notice I'm not saying employer, because that's obviously an issue of contention between the RMTs and the owners and what constitute an employee and employer relationship. And Jason's going to get into that in a few minutes. One of the things, though, that's on the agenda is the issue of privacy and the Protection of Information, Personal Information Protection and Privacy Act. The short answer is that Schedule E to your college bylaws is all you need to know. And Jason's going to go through, no, he's not going to go through the details of Schedule E to your bylaws, but that's where it sets out how the records that you have custody of. And again, I'm not talking about ownership. And some people talk about ownership of files. And whenever we get these phone calls from people, we always get, well, who owns the files? Well, that's an easy one. The client owns the files. I mean, Bodie and I were just commenting on that with Bodie a few minutes ago. The client owns the files in every single situation. Your question should be, who has custody of the files? Under what circumstances? So if an RMT leaves the practice, under those circumstances, who has custody? What are your responsibilities as clinic owners vis-a-vis maintaining custody, both with the RMT in the practice and after the RMT has left the practice? Those are things that are all set out, again, in Schedule E. Now, the tricky part of Schedule E is actually the last clause of Schedule E, which is Clause 10. And I'd invite all of you to look at that, because what it says, in essence, is, and this is my paraphrase of it, this is not what the clause says, is, notwithstanding everything that we told you in Clauses 1 to 9, which says the RMT has custody of those records under virtually every conceivable circumstance. Clause 10 says, oh, but you can have a contract that varies everything else we've just told you. And that is the significance of what Jason is going to go through with you. And because, and I'm sorry, they're in the black folders that we've distributed, and I apologize for the excessive packaging, but law firms aren't the greenest offices around yet. But that is the document that Jason was the principal author of, and that I met with Dennis on earlier, and we went through and made some revisions. This is just a draft. As I said earlier, this is a draft that we've made at the request of the MTA. And I want to say also that, I mean, this is the kind of thing, actually, and I act for, I mean, I'm the senior litigation partner in a business law firm of over 20 lawyers, and I act for a number of organizations. I think the MTA should be applauded for the kind of consistency that they're trying to achieve for your profession here, because this is the sort of thing, the lack of consistency and the lack of uncertainty in these kinds of agreements are what put my kids through school. This ultimately is going to reduce my billings, but is going to make your legal expenses substantially cheaper, and frankly is going to make Dee's job and everybody else at the MTA offices, ultimately, that's the objective, is to make their job simpler. Because when we get to a kind of, I mean, and this is a draft, admittedly, right? Everyone needs to understand that. Frankly, you are the first group that this is being shown to outside of the MTA in our offices, because we're looking for feedback from you as clinic owners as well. It also happens to be a very convenient way for us to go through the issues that are on the agenda here, because they're all canvassed, all right? And so these are the kinds of issues, and so what's on the draft before you is simply our best effort, our best guess, if you like, as to how to address all of these kinds of questions that we've been getting from RMTs and, as we say, the occasional clinic owner, historically. The same kinds of question that, Dee and everyone gets at the office. This is the objective of this document. Over time, it gets refined, right? It's not going to be perfect even once it's up on the MTA website. It's also not a finished document because, as you see when you go through it, and feel free to read ahead, there's lots of blanks. And one of the important blanks you're going to get to is the non-competition clause. And in previous versions of this document, people have tried to come up with shorthands for non-competition agreements and clauses. And as anyone will tell you, the non-competition agreement that is reasonable in Spuzzum is not reasonable in the West End of Vancouver. You simply can't, the enforceability of those clauses depend upon their reasonableness. And so this document does not replace the necessity for some kind of legal advice before you execute it with your contractors, with your RMTs. But it reduces the kind of legal advice you need from, say, 10 hours to 1 hour. And so, my kids are going to have to get a job to go through school, right? They'll still go to school, but they'll need a job, that's all. And that's ultimately the objective of this thing. So that we have some consistency moving forward, and ultimately, the point of this sort of document is so that if it gets widely adopted within the profession, then it does ultimately add to the level of certainty that everybody has about how it works. And the more times that it gets challenged, and the more times that we get feedback from people and we come up with something, and the more times it gets refined, ultimately the better it gets. And so that's why feedback from you is so important, and that's why we thought it was such a good opportunity to take this meeting today to go through it with you. Now, in fairness, we have 30 minutes, and then it's Harry's turn to tell you what happens if, after the best agreements in the world, you still end up on the wrong side of a judgment, you need insurance. And so Jason's going to hit the highlights. We're not going to go through it clause by clause, if you like. We are, however, going to be around after lunch, so if you have specific questions that we don't get to in the main part of the discussion, please feel free to come back to us. Now, just before I turn over to Jason, there's one issue that isn't canvassed in the agreement itself on the face of it, and that's the deep pockets item on the agenda. The deep pockets item refers to a section in the Negligence Act in British Columbia, which basically says that if, and Harry's going to speak to this specifically, but if as a clinic owner, you end up as a defendant in a malpractice action, and you are a co-defendant with the RMT who has, broken someone's spine inadvertently, all right? But you're named because you're named. People like me, we throw everything against the wall and let the court decide ultimately who's going to pay for it. If you are 10% liable and the RMT is 90% liable, and the plaintiff is awarded $100,000, I just want a show of hands in the room, and we'll do multiple choice. Those who think that you are liable for $10,000, put up your hand now.
Good question.
Those who you think are liable for $90,000, put up your hand now. Those who think you are liable for $100,000, put up your hand now. A lot of people aren't putting up their hand at all. But if you put up your hand last, you are correct. Okay? You have the benefit. The Negligence Act in British Columbia says that a court has to apportion liability based on the portion you are at fault. So you'll get a judgment saying you're only 10% at fault. The Negligence Act also says, but the plaintiff has the right to collect all of the judgment from any one of the tortfeasors. So even though you're 10% at fault, you can pay 100% of the judgment, and then you have the right to go after that RMT, who's judgment-proof, by the way, which is why they're coming after you in the first place, to get your money. So this kind of stuff and the insurance that Harry is going to talk to you about later is important. It's important from a business standpoint. It is something you need to take seriously, but in a nutshell, that's the item that refers to deep pockets. All right. The rest of the stuff on here, the ownership, the clinic files, the contracts, the WorkSafe issue to a certain extent, and the privacy stuff, I'm now going to turn over to Jason. He's going to take you through the contract. All right? Thank you.